Will the House please come to order and members kindly take their seats? Just to remind members, we are gaveling back in after a recess. We are working on House Bill 2, which is increasing the minimum age for delinquency proceedings. We've heard the committee's report, and now the member from Rutland City, Representative McGuire, will offer an amendment to the report of the Committee on Judiciary. The first assistant clerk emailed this amendment out to members at 12:41 p.m. today. This amendment also appears on the House Overview webpage, and paper copies are available at the main table. Member from Rutland City.
Thank you, Madam Speaker. I'm just going to take a quick second just to review the amendment that I proposed. First, by striking sections 5 through 11 and their reader assistant headings in their entirety. Second, by inserting a new section 5 and reader assistance heading to read as follows. Madam Speaker, when enacted in 2018, Raise the Age had 2 steps. Step 1, to raise the age to 18 for use to be subject to juvenile proceedings in the family division. That step went into effect and remains in law to this day. Step 2 of raise the age was extended even further to add 19-year-olds to jurisdiction of the family division. Step 2 was originally slated to go into effect in 2022, but the effective date was delayed several times by the legislation and is scheduled to go into effect in just under 3 weeks on April 1st. My amendment proposes to preserve Step 1, so 18-year-olds remain in the family division, and to sunset Step 2, so 19-year-olds remain where they currently are in the criminal division. Madam Speaker, this amendment is not in any way a repeal of Raise the Age. It simply keeps us exactly where we are. Pure and simply, this is not this is not a repeal of the Raise the Age. Doing so would be unconstitutional. Why? As 18-year-olds already have benefited from the original law. What this does is sunset a piece of the original bill that has already been delayed by the legislation, will be the 3rd time. And in a nutshell, it's common sense. So I ask for your support, and I ask when this comes to vote, it's done by roll. Thank you.
The member from Rutland City requests that when the vote is taken, it be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. Member from South Burlington.
Madam Speaker, not to get into just what the semantics here, but it is repealing the second step of raise the age to 19. Now, this is a repeal. It wouldn't move forward with the step that we've been pushing for a while, for very good reasons, and reasons that the administration, as far as the individuals who deal with these issues, has supported for a very long time. So just to, if I may read from testimony from the Juvenile Justice Director that was provided to us actually last year when we were considering this, if I may read from that.
You may.
Written testimony. She stated that, I want to start by saying that in response to the potential delay of final implementation of Raise the Age, that we support the research behind expansion of juvenile jurisdiction and having a response that is tailored to the young person's development stage. From a report, their latest report, which was in January of this year, related, the reporting requirement. They also showed or explained that they do have support for this concept. This is from, if I may read from the January 27th, 2025 DCF report.
You may.
DCF does not challenge the well-documented developing brain science that suggests that with continued access to normative development, youthful brains will naturally desist from delinquent or criminal antisocial behaviors as they mature. Admittedly, they went on to say that they wanted to end going to 19 at this time. Their view is we're not ready. But I've not gathered from the last 2 years of hearing from DCF that it is not a good idea. They're just simply not ready, and we need to get there. There's other individuals who have supported this as well. And if I may read from the testimony of the Chief Juvenile Defender.
You may.
We're disappointed that we're not in a position now where we're hearing everybody sort of enthusiastically saying we're ready to go forward to age 19. But we don't want to go forward in an environment where people feel unprepared and where expansion is essentially doomed for failure because there's people who are not ready for it to go full. The juvenile defender, however, made very clear that this is the right thing to do for this age group to set them on the right path instead of sending them into the criminal courts. May I read from the testimony of the director of the Office of Racial Equity? Madam Speaker. We support the implementation of Raise the Age, but we're extremely nervous, hesitant, frustrated, and apprehensive about the current state of the system and whether it can actually support a successful implementation. The director went forward and explained what needs to be done to get there, and those are things that we are having DCF report on and that we're going to be continuing to put pressure on them to do that. Finally, if I could read from the testimony of the Council for Equitable Youth Justice.
You may.
So we're in support. I think the council would have the same caveats, however, that you've heard from the last two presenters above. Is the timing right? And that's the real issue, is the timing. Is the timing right now? They also went into depth in their testimony, explaining the brain science, explaining how research shows that individuals going through juvenile justice type systems have better outcomes than people going through criminal justice system. So we need to continue to have the goal of reaching 19. We need to continue to work with the Department of Children and Families so that we can get there appropriately. You know, the presumption should not be that we're not going to get there. So I ask the body to vote no on this amendment.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City? Are you ready for the question? Member from Poultney.
Madam Speaker, to my knowledge, there is one state in the union that actually has raised the age to 19, and that is the Commonwealth of Massachusetts, which I believe took effect last year. We do not always have to be the first or the second in the nation. We've delayed, and we've delayed for several years now. My sense is we are not ready right now, and I think this is the common sense approach to putting a pause on this. Why don't we see how the Commonwealth of Massachusetts handles this and how they grapple with what I would assume their DCF grapples with the lack of bodies to actually employ to do the job. So I will be in support of this amendment. Thank you.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City? Member from Williston.
Madam Speaker, I rise to oppose this amendment. The 2018 legislation that passed and was signed into law by the governor that initiated everything that's happening now and was the original Raise the Age legislation was the result of extensive testimony that detailed the brain science underlying the Raise the Age initiative. None of that science has changed, nor has it been or is it being challenged. I also want to point out for members, we heard in testimony, that many of the youth who wind up in both juvenile and criminal proceedings have been at one time in the custody or somehow otherwise interacted with the Department for Children and Families. We know that many of the systems as part of that department are facing serious challenges, and ultimately, through no fault of the committed employees at DCF, the systems fail those children. We cannot punish them for the failings of our own system. Raise the age is the right thing to do.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City? Are you ready for the question? Member from Northfield.
Thank you, Madam Speaker. Just to touch on a little bit of broader history, when I first came to the legislature, and I don't want to overdate that, but many members of this body were likely in grade school at a minimum, 16 and 17-year-olds in the state of Vermont had charges brought against them starting in criminal court. It took a waiver to move them to family court. It was a slow process, and Vermont was actually one of the last two in the nation to bring that, to include 16 and 17-year-olds to start their cases in family court, and then the ability to move them to adult court for serious crimes. I was part of fighting for that change, wanting to see that move, seeing it as an important move. But there is such a thing as going too far. We actually, quite a ways back, created a status called the youthful offender, which was specifically intended to be able to address developmental needs and to recognize that 18 to 22-year-olds are not the same as a 35-year-old, that we need to address the special handling and the special attention needed for that age group, given the developmental needs and the brain development. It doesn't mean that we should turn them into and label them as children, which they are not, except under this statute. I note that we call them children and say that their developmental ability to make choices and think through what they're doing is still in development at those young adult ages, but we make it only for certain crimes. So if we're resting on the science, or saying we're resting on the science, we're saying that a 19-year-old can't think through the consequences and take responsibility in adult court for actions for shoplifting. But if it's a more serious crime, if it's a assault with a weapon, their thought process is able to change and they're suddenly more mature. Instead of recognizing that developmental, which is of course separate and individual, but the developmental status applies to all of those decisions. The result of these various changes is that we have a grid that might stun many people to attempt to follow. I call it a grid. It's not really a grid because a grid has a row of things here and a row of things here, and then logical lines between. It wouldn't work as a grid because there's too many subcategories. We're dealing with which crime it is, how serious a crime, and that's not just between misdemeanor and felony, but also between felony and the more serious felonies, except that some of the most serious felonies only apply to certain ages and not to others. Then we're dealing with those different age categories, a number of different ones. And then we're dealing not just with what court they are in, but what status in which court, youth offender and adult court versus family court. And then we're also dealing with where the case starts versus when, if, and how it might move, either from adult court or youth offender to family court, or from family court to youth offender or to adult court. It's a complexity that defies logic, defies the ability for even adults with full developmental thinking capacity to figure out where one would go. And one of the things that we know most about deterrence to criminal activities is that people understand what the consequences are. There's no way you could follow our statutes and figure out which placement you would end up in that statute. I think what we really need is a far more robust youthful offender statute that more actively takes into account, as it already does, but more actively is tailored to the developmental stage, that has that full focus on rehabilitation, and that rapidly allows for sealing of records when it was in fact clearly a developmental issue that is not continuing. I think with clearer lines, we could do things that make a lot of sense for our young people without decreeing that some of them are children. I think it's also clear that we won't be ready to make this change to family court that's proposed in the deferred raise the age within 2 years, because we don't yet have any kind of a secure setting for those few young people who do need a secure setting, even in the planning over the next 2 years. Planning to build some sort of a facility, even a small one, 6 or 8 beds, takes, as we know well, years and years. We've been years in developing something for those under age 18. It's been recently clarified and announced that the youth campus that's now starting the development process will only be for 17 and under. So we remain without even a plan for treatment and rehabilitation status for 18 or 19-year-olds who need to be, at least for a short time, in a secure setting. Repeal, I believe, would force us to really rethink a logical, progressive, very developmentally adapted system for dealing with that group of young people who still need guidance and rehabilitation, not punishment, but who are not children and do not belong within an agency whose entire focus is with true children, those under the age of 18. So I would urge support for this amendment.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City, member from South Burlington?
Madam Speaker, just a few comments relative to what we just heard. So, admittedly, it's a complicated and complex process. And we took a step towards addressing that last year when we passed a bill that created a task force with the Defender General, Department of Children and Families, the court, the prosecutors, to come back to us December of this year with a plan to reduce that complication of as far as who starts where and such. But that's really beside the point. That's not relevant to what we're talking about here today with the raise the age to 19. I did mention in my report the youthful offender, and wasn't going to get too much into that, but I will say a couple things about that now. It's not the same as an individual going into the delinquency. There are some pretty important differences. One of them is that it's not confidential. It usually starts, there can be some exceptions, but it usually starts in criminal court, and it's not a confidential proceeding. Eventually, if youthful offender status is granted, it goes to the family court and becomes confidential, but the cat's out of the bag at that point. It's already become public. Also, it's subject to the discretion of prosecutors and judges. And what that means is that you can get geographic disparities on how youthful offender is being implemented. If we have certain individuals or 19-year-olds with certain crimes going into the delinquency court, that takes away that part of the geographic disparity. So as far as what crimes and what ages start where, that's long under development, involves a lot of compromises, but we're going to be taking a deep look at that after we get the report back in December. And we are going to continue to look at improving our our youthful offender statute as well. But as far as compromise is concerned, we hear a lot about wanting compromise. this session. So at the beginning of the session, I understood from the administration that their position on this was to repeal the 19-year-olds, not go ahead with the 19-year-olds. The position from a lot of other people I was hearing from, including in my caucus, is we need to go ahead on April 1st. This delay is the compromise. This is the compromise that I believe, and I made sure that I've been in contact with the other body. I've made clear what we've been working with to the administration. It was at least my understanding that everybody agreed that this was a compromise. So I ask the body to stick with this compromise and vote no on the amendment.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City, member from Northfield?
Thank you, Madam Speaker. I just want to briefly clarify, when I was referencing and discussing the youthful offender status, I framed it as an aggressive reform to an expansion of how we address the youthful offender status, that would make a lot more sense than moving young adults into child and these different moves back and forth. There are weaknesses in the current young offender status, and I think those need to be addressed. That's what we need to rethink about how we are dealing with 18 to 22-year-olds who are young adults, but not children.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City? Are you ready for the question? If so, will the clerk please call the roll?
Arsenault of Williston.
2 minutes. Will the House please come to order and members kindly take their seats? Will the House please come to order? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of an electronic device. Please refrain from the passing of notes and conversation during a roll call. And when the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your votes. The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Rutland City? Will the clerk please continue to call the roll?
Austin of Colchester. Bailey of Hyde Park. Bartholomew of Heartland. Bartley of Fairfax. Berbecco of Winooski. Byrong of Vergennes. Bishop of Colchester. Black of Essex. Bloomley of Burlington. Boslin of Westminster. Posh of Clarendon. Booton of Berry City. Boyden of Cambridge. Brady of Williston. Brannigan of Georgia. Brown of Richmond. Burdett of West Rutland. Burke of Brattleboro. Burkhardt of South Burlington. Burrows of West Windsor. Burt of Cabot. Campbell of St. Johnsbury. Canfield of Fairhaven. Kerr-Stunken of Whitingham. Casey Montpelier. Casey Hubbardton. Chapin of East Montpelier. Charlton of Chester. Christie of Hartford. Chena of Burlington. Coffin of Cavendish. Cole of Hartford. Conlon of Cornwall. Cooper Pownell. Corcoran of Bennington. Cordes of Bristol. Critchlow of Colchester. Damar of Venusburg. Dickinson of St. Albans Town. Dobrovich of Williamstown. Dodge of Essex. Dolan of Essex Junction. Dolgan of St. Johnsbury. Donahue of Northfield. Duke of Burlington. Durfee of Shaftesbury. Eastus of Guilford. Emmons of Springfield. Feltus of Linden. Galfetti of Barrytown. Garifano of Essex. Goldman of Rockingham. Goodnow of Brattleboro. Ghostland of Northfield. Granny of Jericho. Greer of Bennington. Gregoire of Fairfield. Hengo of Berkshire. Harpole of Glover. Harrison of Chittenden. Harvey of Castleton. Hedrick of Burlington. Higley of Lowell. Holcomb of Norwich. Hooper of Randolph. Hooper of Burlington. Houghton of Essex Junction. Howard of Rutland City. Howland of Rutland Town. Hunter of Manchester. James of Manchester. Kosenska of Burke. Keyser of Rutland City. Kimball of Woodstock. Klepner of Burlington. Kornheiser of Brattleboro. Fresno of South Burlington. Labor of Morgan. Lally of Shelburne. Lalone of South Burlington. Lamont of Morristown. LaRush of Franklin. Lipsky of Stowe. Logan of Burlington. Long of Newfane. Luna of St. Albans City. McGuire of Rutland City. Malay of Pittsford. Marcotte of Coventry. Maslin of Thetford. McCann of Montpelier. McCoy Pulteney. McFawn of Berrytown. McGill of Bridport. Mickless of Milton. Mahali of Callis. Minier of South Burlington. Morgan L. of Milton. Morgan M. of Milton. Morse of Springfield. Morrissey of Bennington. Morrow of Weston. Rowicki of Putney. Nelson of Derby. Nielsen of Brandon. Niagara of Bennington. North of Ferrisburg. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie of Burlington. Oliver of Sheldon. Olson of Starksboro. Page of Newport City. Parsons of Newberry. Pezzo of Colchester. Pincenald of Dorset. Pouch of Heinsberg. Powers of Waterford. Priestley of Bradford. Pritchard of Powlett. Quimby of Linden. Rachelson of Burlington. Sakowitz of Randolph. Shy of Middlebury. Sheldon of Middlebury. Sibilia of Dover. Southworth of Walden. Squirrel of Underhill. Steady of Milton. Stevens of Waterbury. Stone of Burlington. Supernut of Barnard. Sweeney of Shelburne. Taglivia of Corinth. Taylor of Milton. Tomlinson of Winooski. Toof of St. Albans Town. Torrey Moortown. Walker of Swanton. Wazasak of Berry City. Waters Evans of Charlotte. Wells of Brownington. Wells of Brownington. White of Waitsfield. White of Bethel. Winter of Ludlow. Wood of Waterbury. Yakavoni of Morristown. Brannigan of Georgia. Cordes of Bristol. Easties of Guilford. Lipsky of Stowe. Logan of Burlington. Oliver of Sheldon. Rachelson of Burlington. Wells of Brownington.
Members, please listen to the results of your vote. Those voting yes, 55. Those voting no, 86. The nays do have it, and you have declined to amend the report of the Committee on Judiciary. Now the question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? Member from Rutland City.
Madam Speaker, raising the age of criminal responsibility to 19 risks undermining accountability, potentially overlooking serious offenses committed by older youth, and could even lead to the perception that older youth are not responsible for their actions. which could increase reoffending. Raising the age could create a perception that older youths are not responsible for their actions. Serious offenses committed by individuals 18 years or older would be treated as less serious, which would undermine public safety, leading to a weaker deterrent effect and an increase in recidivism. Instead of focusing on accountability and deterring crime, raising the age could potentially create an environment where older youth feel less inclined to take responsibility for their actions, which could lead to a greater risk of reoffending. It is essential to consider the complexity of youth offending, including the role of trauma, social issues, and developmental differences, rather than simply focusing on the age of the offender. A more holistic approach that addresses the underlying causes of youth offending and quality investments into youth rehabilitation programs are a practical, applicable strategy, not raising the age. Thank you.
Member from Waterbury.
Thank you, Madam Speaker. I just want to, because of the jurisdictional nature of a portion of this bill, the House Human Services Committee took testimony on it and reviewed it, and by a straw poll approved this bill by a vote of 7-2. Madam Speaker, may I make a few comments?
You may.
Wasn't sure if that was
You have the floor.
in order. Okay, thank you. So as the committee that spends a great deal of time, I will tell you, a great deal of time with the Department for Children and Families, I can speak to the fact that while at some levels they are doing an excellent job, at other levels they are still struggling. And for folks who might not have the history behind some of those struggles, a considerable number of years ago now, there was the closure of the Woodside facility. And although there's probably lots of arguments about whether that was an effective facility, and there certainly were issues that occurred there, it also did serve a purpose, frankly, that we lost when that facility closed and a different type of facility was built on those grounds. And the Department for Children and Families, frankly, has been struggling to recover from the loss of that facility as a resource. They do have a plan, and they are making steps towards implementing that plan. Whether it is fast enough for all of us, I would say there's probably differing opinions about that. But I can tell you unequivocally that they are not prepared to do it at this point in time. That does not negate, however, the goal and the policy that this body passed several years ago and the science behind that. And we all strive to make our decisions based upon science. And yes, common sense does play into science as well and our interpretation of those scientific facts. And so I really urge the body to support H2 as it does both, frankly. It provides a level of accountability to DCF, and it still recognizes the fact that we will hold folks in their younger adult ages accountable for the actions that they take. It does not negate the fact that there is accountability for those actions. It's just being done in a different way that is more consistent with the development of the young brain at that point in time. Thank you.
Member from Northfield.
Thank you, Madam Speaker. My hope would be that with an additional 2 years, which I hope will pass, it will give our body the opportunity to work, as the chair indicated, on the recommendations regarding that complex grid, but also look more deeply at the opportunity for reform and revitalization and age-appropriate responses within the youthful offender category, and to consider including 19-year-olds there. The other alternative, I fear, will be that we will reach 2027 and find that DCF still doesn't have the staff resources and almost certainly will not have any kind of secure capacity for the small number who may need that. And we will be back in the same place that we are today. Thank you.
Member from Essex Junction.
I rise in support. H2 strikes a balance between the need to meet our public safety challenges while also advancing strategic and necessary improvements to Vermont's juvenile justice framework. Increasing the age of delinquency to 12 is supported by brain science and aligns Vermont with minimum delinquency ages in surrounding states. And while I support raising the age to 19, and on the other end, the age range for delinquency, I also understand that now is not the right time if we want this to be successful. H2 makes thoughtful changes to ensure that our juvenile justice system is working effectively, and I ask for the body's support and ask you to vote yes.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Member from Burlington.
Madam Speaker, although I'm disappointed that we can't move forward at a quicker pace, I accept this compromise as the best path forward at this time after hearing about the work of our committee on judiciary to explore the issue and the preparedness of our system. I think it's important that we hold people accountable, but I would like to remind members that we need to balance accountability with care, and that we need to respond to human behavior with actions that don't perpetuate the behaviors that we are wishing to extinguish or deter. And unfortunately, the evidence shows that the criminal justice system, especially incarceration, is a costly yet ineffective way to change criminal behavior, not only for youth, but for all humans. It's often said that age is just a number. And I've been learning a lot about this thing in psychology called temporal perspective, which is about our concept of time and how human development can be impacted by trauma in a way that affects not only our concept of time, but our understanding of consequences. And age is a number related to the revolution of the earth around the sun. And these numbers that we've picked come from certain cultural conceptions that are being challenged by recent science, which show that the average female brain matures at 22, the average male brain at 26, that transgender brains somewhere in between. And so we are learning that there is quite a bit of variance. Furthermore, some humans, their brain stops at a certain level of development, regardless of age. There are people who are age 70 whose executive functioning is equal to a 16-year-old, and furthermore, there's cognitive decline in elders that affects their judgment. So when we're talking about raise the age, we need to be thinking broader, and I'm grateful to the committee for doing further work on youthful offender status, for committing to doing further work on looking at human development. And in closing, I just want to remind members that we're talking a lot about developmental unevenness and challenges with brain development, but let's not forget the research on neuroplasticity. We used to be told that when brain cells die, that's it. But what we are learning is that the brain regenerates, that the brain can rewire, and that with the right environmental conditions, that even our genes can change, be activated or shut off. And we are on the edge of scientific breakthroughs that are going to revolutionize how we respond to addiction, to criminal behavior. So let's not forget the hope that lies ahead. And let's not forget that when we hold people accountable, if we stay committed to this path, we can provide them the care they need to recover, to be rehabilitated, and to find redemption at any age. Thank you.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Member from South Burlington.
Madam Speaker, just a reminder and reality check that if we do not pass this bill, this is going to go into effect on April 1st. Some people may like that, but they're not ready for it. So I ask for the body's support to vote yes for H2. Thank you.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is House Bill 21, which is an act relating to service of rights of possession. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Pittsburgh, Representative Millet, will speak for the committee. Please listen to the second reading of the bill.
H21, an act relating to service of writs of possession.
Member from Pittsburgh.
Madam Speaker, H21 can be found on page 242 of today's calendar. The bill concerns the authority of sheriffs to serve a particular type of court order known as a writ of possession. In Vermont, sheriffs generally have statewide law enforcement authority, and this includes the authority to serve criminal and civil court process throughout the state. In this context, court process means court papers and orders, such as a complaint if a person has been sued, a summons to a defendant in a criminal proceeding, or a subpoena to a witness in a civil or criminal proceeding. These court papers often must be personally served on the affected party, and generally any sheriff has the legal authority to serve any court process throughout Vermont. However, some specific types of court proceedings have particular rules about serving process, and H21 involves one of them, called an ejectment proceeding. A property owner can bring an ejectment proceeding when the owner's property is being unlawfully occupied, when a person unlawfully builds a structure on another person's land. In these types of cases, the landowner can file an ejectment action in the civil division of the Superior Court. If the court agrees that the defendant is occupying the property unlawfully, the court can issue a writ of possession, which is a court order directing that the defendant vacate the property and that the plaintiff be put into possession of it. This writ of possession order can be served by the sheriff, who can also put the plaintiff into possession if the defendant refuses to leave. The ejectment proceeding statutes, however, contain an unusual limitation on sheriff's authority to serve writs of possession. In these cases, the writ of possession can only be served by the sheriff of the county where the property is located. This limitation has been in effect since the statute was passed in 1979, and research has not produced any reason for it. H21 addresses this situation by allowing sheriffs in any county to serve a writ of possession. This makes service of writs of possession consistent with the general authority of sheriffs to serve court process throughout the state. Section 2 provides that the act take effect on passage. The committee heard from the president of the Vermont Sheriff's Association, Legislative Council, Sheriff of Chittenden County, an attorney, and Chief Superior Judge of Vermont Judiciary. The committee vote was 9-0-2, and we ask for your support.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. And next is House Bill 105, which is an act relating to expanding the Youth Substance Awareness Safety Program. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Brattleboro, Representative Goodnow, will speak for the committee. Please listen to the second reading of the bill.
H105, an act relating to expanding the Youth Substances Awareness Safety Program.
Member from Brattleboro.
Before the chamber is a strike-all amendment to H 105 entitled An Act Relating to Expanding the Youth Substance Safety Awareness Program. Madam Speaker, this bill aims to address the very serious issue of youth alcohol substance abuse and impaired driving by expanding the eligibility for age-appropriate programming and imposing common-sense consequences for youth who are driving while impaired. It is hard to emphasize enough how critical it is that when youth are caught engaging in incredibly dangerous behavior, like drinking and driving, that they both experience immediate consequences for their actions and also receive the supportive programming that they need to hopefully course correct and stop the behavior. H 105 works towards that goal. Specifically, this bill proposes to expand the Youth Substance Safety Awareness Program in 3 ways. First, by converting impaired driving violations for those under 21 years of age who provide a 0.02 blood alcohol content breath sample to a civil violation rather than a delinquency. Second, requiring that underage 0.02 violators enroll in the Youth Substance Safety Awareness Program and have their license suspended. And 3, including those of 12 years of age or older who commit violations related to alcohol procurement, consumption, possession, or impaired driving in the Youth Substance Safety Awareness Program. Before I get into the substance of the bill, it's important to know about the Youth Substance Awareness Safety Program, which, Madam Speaker, I will refer to as the program during the rest of my presentation. The program provides an alternative to the civil court process for youth who violate Vermont's underage alcohol laws. The program is educational and rehabilitative service that helps young people understand the impact on themselves and others of using of these substances and to lower the risk for future use, while also connecting those identified as high risk to professional substance use clinicians. Importantly, this program is carefully tailored towards youths to be as effective as possible at addressing concerning substance abuse behavior during these formative years. I will now take you through the bill, which can be found beginning on page 244 of today's calendar. Section 1 of the bill amends 7 VSA 656 by rolling in the underage impaired driving provisions of 23 VSA 1216 into a new proposed subdivision of 656A1D and A3. In addition to some technical corrections to the organization of the statute, the bill adds that those who are 12 but not yet 21 years of age and engage in impaired driving with a blood alcohol concentration of 0.02 or more will commit a civil violation that will be handled by the Judicial Bureau. Currently, such impaired driving violations are considered delinquencies and are handled in the family court. This change aligns such impaired driving violations with the civil treatment afforded for underage violations related to procurement, possession, and consumption of alcohol. While all violators of this section, both those related to driving and non-driving, are required to enroll in the Youth Substance Awareness Safety Program, the difference proposed in H 105 is that impaired driver violators will also have their license suspended under subdivisions 656A3 and A3B. So, for the first offense, a youth will have their license immediately suspended for a period of 90 days, and for a second or subsequent offense, for 145 days. A youth's license will be automatically reinstated after completing the suspension. Madam Speaker, there was much discussion in your Judiciary Committee regarding these suspension periods, both why they are necessary and what length of time was appropriate. While effective programming is critical, we felt that it was also important for there to be an immediate consequence for a youth who engages in such dangerous behaviors as underage drinking and also drinking and driving. We feel that these suspension periods are both just and they nest well with the civil DUI suspension periods. Similar to violators of subdivision A2, if impaired drivers fail to complete the program, their case will go before the Judicial Bureau to be treated as a civil violation with potential penalties, including fines of $300 and $600, and critically, an additional license suspension of 180 days for a first offense, or 1 year, or until the youth turns 21, whichever is longer, for a second offense, in accordance with subdivision A3A. An offender will receive credit for any of the elapsed period of suspension served already. So if you're a youth, a first-time offender who does the 90-day suspension and you failed to complete the programming, you would then have the 180-day suspension, but you get credit for those initial 90-day suspensions that you already served. So this creates a carrot and stick. Under H105, a youth will suffer an initial license suspension. Then, if they are willing and able to engage in and complete the programming, they will not have any additional license suspension. Should they fail or choose not to engage in the program, then they will suffer an additional significantly harsher license suspension. So we've created an incentive for youth to engage in the programming that is so critical to addressing this problem behavior early. If someone were to have their license suspended after failing to complete the programming, they would have to go through the standard reinstatement procedure once the license suspension is served, as described in subdivision A3C. As is in current law, now redesignated within subdivision A3A, which can be found on page 246, an alleged violation of section 656 does not bar a criminal prosecution that can be charged under that could be charged. But subsection B makes clear that a person cannot be cited for more than one violation of 656. So this means that a youth could also be charged with a criminal DUI, depending on the facts and the all-important prosecutorial discretion. A new section found on page 248C proposes the suspension notice procedure, which requires law enforcement officers to issue a notice of suspension that includes information concerning the suspension's effective date, duration, an explanation of the suspension consequences, methods to requiring a restricted license, and the projected date of the license reinstatement. A restricted license means that an individual could get an interlock device at their own expense. Amendments to section H outline confidentiality and public records exceptions, considerations that permit the reporting of license violations to law enforcement and insurance companies. The addition of subsection I found on page 251 requires that the Attorney General reports to the standing committees of jurisdiction concerning the number of persons referred to the program, their ages, the number of successful completions, the number of failures, and the number of people who served suspensions imposed by the Judicial Bureau after they failed the program. Section 2 of the bill creates a specific requirement for the first report from the Attorney General, which mandates that the Attorney General's office, the Vermont Statistical Analysis Center, and others propose outcome measures to assess the effectiveness of any suspension imposed for impaired driver violations and the program under 7 VSA 756. Sections 3 and 4 repeal 7 VSA 756A and 23 VSA 1216 and a reference to section 1216, since they are being eliminated and modified and rolled into 7 VSA 756. Finally, section 5 of the bill states that it will go into effect on July 1st of 2025. Madam Speaker, we heard from the following witnesses: the Youth Restorative Programs Manager from the Burlington Community Justice Center, the Adolescent Service Director from the Department of Children and Families Family Services Division, the Director of the Court Diversions and Pretrial Services, Legislative Attorney from the Vermont Department of State's Attorneys and Sheriffs, Legislative Counsel from the Office of Legislative Counsel, Deputy Defender General and Chief Juvenile Defender from the Defender General's Office, the Vermont State Police Safety Programs Unit Commander from the Department of Public Safety, Executive Director from the Washington County Diversions Program, and the Deputy Commissioner from the Department of Motor Vehicles. All of those witnesses were in favor of H105 as amended. And Madam Speaker, this bill aims to address the very serious issue of youth alcohol substance abuse and impaired driving by expanding the eligibility for age-appropriate programming and imposing common sense consequences. The committee vote was 8-1-2, and I ask for your support.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, that completes the orders of the day. Are there any announcements? Member from Burlington.
Tonight is Farmers Night. Lisa Jablow and the Vermont Symphonic Winds will be joining us here in the chamber at 7:30. Hope to see you all there.
Are there any further announcements? Will the House please come to order? Member from Williston.
Tomorrow afternoon at noon in room 10, the Women's Caucus will meet and we will be hearing from representatives from the Department of Corrections, BGS, as well as the Chair of House Corrections and Institutions to receive an update on progress toward a new women's correctional facility. All are welcome.
Are there any further announcements? Seeing none, member from Poultney, can you please offer us a motion to adjourn until Thursday, March 13th at 1 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Thursday, March 13th, 2025 at 1 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and this body stands in adjournment until tomorrow at 1 p.m.